Good afternoon and welcome. Thank you for bearing with me for the last 5 minutes while we sorted out some minor technical issues. So I'm Mailene Wheeler. I'm one of the managers in the Superannuation Advisory team, and I'm going to be running you through our quarterly superannuation update. So, as you would have seen before as I was flicking back, here's our important disclaimer. Some information about me and my contact details if you want to get in touch with me in regards to any self-managed super fund issues you'd like to discuss. All right, the agenda for today. We are going to look at the key super-related lodgement and payment deadlines. We're going to have a look at the status of legislation that's super-related. We're going to have a review of the ATO website updates in recent months that pertain to super. We're also going to discuss some of the super announcements that have been in the news since our last quarterly update. We're going to look at unexpected events and a brief discussion on what will you do if the unexpected happens, which then ties in very nicely to my discussion on the Norman case, which the Supreme Court of Queensland made their decision. It has some long-reaching impacts for superannuation funds, for your estate planning, and just in general, your use of powers of attorneys. And we'll go into some background information because we were acting with Cooper Grace Ward for this client. Okay, so upcoming dates. So please note that this table doesn't include the lodgement deadlines in relation to activity statements and PAYG instalments, but 28th of October is our next date, coming up very quickly. This is the due date for employers to make their super guarantee payments for the September 2018 quarter. It's also the due date for our transfer balance account report, or TBAR, as we refer to it in the industry, which is due for any transfer balance account events that occurred during the 2017-18 year and the September 18 quarter for SMSFs that report quarterly. 31 October 2018 is the due date to lodge and pay your annual tax return for your super fund if you have prior year tax returns outstanding. It's also a due date to lodge for newly registered funds who have been given this date. For those funds that have their 2018 SMSF return due on this date and have had a TBAR event, this will be the date that they are due to report. It's the day to lodge your Departing Australia Super Payments annual report and to lodge your lost members report for the period 1 January 18 to 30 June 2018. Now, 28th of November is the due date for lodging and paying super guarantee charge statement where employers did not make their September quarterly payments by the 28th of October. All right, so let's look at legislation updates. So we have some draft legislation. So the Treasury released some draft legislation covering budget proposal to provide a 1-year exemption from the work test for superannuation contributions. So the aim of this is to allow recent retirees to be able to boost their super balances. So it's going to amend the legislation in the SIS regs and the RSA regs so that they can have a 1-year exemption from the work test that applies so they can put money in without having to satisfy that. So consultation with Treasury is open until the 26th of October. This is a good measure. It allows people to get some more money in super. So we always like that. All right, so bills awaiting royal assent. The Treasury Law Amendments Enhancing Assets Capabilities Bill 2018 is now awaiting royal assent. So the amendments relating to competition in the financial system were contained in this one, and it passed both houses on the 17th of September 2018. Oops. So the following superannuation-related bills are awaiting progress in the Senate, and Senate will sit again from the 15th of October. So we have had the Treasury Laws Amendments Protecting Your Super Package Bill 2018. So this bill limits fees on low-value accounts, bans exit fees, prevents opt-out insurance for new members under age 25 and smaller account balances, and it's supposed to strengthen the ATO's role in reuniting small inactive balances by requiring the transfer of all superannuation savings with a balance below $6,000 to the Commissioner of Taxation if an account related to a MySuper or Choice product has been inactive for a continuous period of 13 months. It also enables the Commissioner to consolidate amounts that have been paid as unclaimed money in active low balance accounts and lost member accounts into an active superannuation account where the reunited balance would be greater than $6,000. The other bills that are still sitting before Parliament that were here when we went through our last quarterly update are the Treasury Laws Amendments 2018 Measures Number 4 Bill, which looks at the superannuation guarantee integrity measures, the extension of single touch payroll, and some superannuation fund reporting. We also have the Treasury Laws Amendment 2018 Superannuation Measures Number 1 Bill 2018, which looked at that superannuation guarantee amnesty, which would allow employees with multiple employers, would also look at employees with multiple employers, non-arm's length income of superannuation entities, and the limited recourse borrowing arrangements. Still there is the Treasury Laws Amendment improving accountability and member outcomes in Super Measures Number 2, Bill 2017. It amends the Superannuation Administration Act to allow employees under workplace determinations and enterprise agreements made on or after 1 July 2018 to have the right to choose their superannuation fund and provide that amounts sacrificed under an employee salary sacrifice arrangement will not reduce an employer's mandated superannuation guarantee contributions. We also have the Superannuation Excess Non-Concessional Contributions Tax Amendment for the NDIS scheme funding, which increases the rate at which excess non-concessional contributions tax is payable on an individual's excess non-concessional. So that was to increase from 47 to 47.5. And the other bill is the Superannuation Excess Untaxed Rollover Amounts Tax Amendment, which is also part of the NDIS scheme funding, which was looking at increasing the rate at which excess untaxed rollover amounts tax would be payable, increasing that as well from 47 to 47.5%. All right, let's have a look at some of the ATO website updates that are super related. So the ATO has recently updated their page on events-based reporting for SMSFs. So SMSF events-based reporting and obligations associated with the transfer balance cap. There's a whole lot of useful information that is there for trustees, advisors, anybody who's still trying to get their head around what we have to do. There's also information about what to do if you're receiving a commutation authority, and we're seeing a lot of those start to come out now. The KiwiSaver scheme payment statement and the instructions for APRA-related funds have been released. So the KiwiSaver scheme payment statement authorises a complying APRA fund to pay the balance of a member's super interest to a KiwiSaver scheme under the Trans-Tasman Portability Arrangement. There's a link there that will take you through, so if you need one of those, you can obtain it. They've also updated their page on paying benefits. The super funds paying benefits may need to consider the conditions of release with the new transition to retirement income streams and whether they are in a retirement phase or not, calculating taxable and tax-free components of benefits, departing Australian super payments, income streams, death benefits, PAYG withholding, and the taxation of benefits. There is also the speech from administration issues under the transfer balance cap. So Acting Assistant Commissioner Tara McLaughlin discussed administration issues under the transfer balance cap as part of an expert panel at the Tax Institute's National Super Conference. So the full speech is available on the ATO's website. Okay, let's look at some of the super news announcements that have been made in recent months. So we have Labor's announcement to improve women's superannuation security. So the federal opposition announced on the 19th of September 2018 that a shortened Labor government would invest $400 million to strengthen Australia's superannuation system and essentially boost women's super balances. So some of the proposed measures include making sure that recipients of the Commonwealth paid parental leave and the dad and partner payments would continue to receive super contributions. They're looking at phasing out the $450 minimum monthly income threshold for the eligibility for the superannuation guarantee. This is recognising that there are people who are being disadvantaged because they work part-time, they work casually, or they are in multiple low-paid jobs. They're also wanting to make it easier for employers to make employers to make extra payments into a women's superannuation fund, and looking at improving the transparency by committing to consider and publish the impact that any future changes to super would have on women. We've also had the Medicines Australia, in conjunction with Victoria University, released a report finding that a staggering $20.8 billion is being lost in superannuation each year due to early retirement from ill health, which is something really important to consider when it's Mental Health Week. So this is costing approximately $45.3 billion to GDP. The report finds that implementing effective health strategies for those who are at risk of early retirement due to ill health, including medicines, has the potential to recover $1.9 billion in super and return $3.9 billion to the economy. Now, it was conducted by a research team led by Professor Bruce Rasmussen at VISEF, and the report analysis involved a wide range of data sources from the Australian Bureau of Statistics, Household Income and Labour Dynamics in Australia survey. So launched on the 17th of September 2018 as part of the Medicines Australia Pharmos 18 Annual Symposium of the Health Industry, they've said that it's quite clear from this report early retirement to ill health is not only hard on individuals, their families and carers, but it's also hurting the Australian economy. The ATO's Tara McLaughlin, Acting Assistant Commissioner for Superannuation, and Dana Fleming, the Assistant Commissioner, presented to the SMSF Technical Day, SMSF Association Technical Day. So they went over issues of, fledgling SMSFs, the first 18 months of an SMF's life. Their speech covered their insights into motivations, behaviours, and the drivers of both trustees and for the professionals who support SMSFs. So their full speech is available. And the key topics that they covered include the right and wrong reasons for setting up an SMSF, the role of the ATO, how professionals can help trustees, the risk factors, structural and setup issues, the first year of operation, reporting and lodgement obligations, the investment rules, where trustees don't take their responsibilities seriously, and running an SMSF the years after the initial establishment. So I think it's something that's really important for people to look at if they're considering starting a super fund, or if you have an SMSF and you want to go back and refresh yourself over the things that you need to be considering. This is a great little, place to start. All right, and other super news, the Class SMSF benchmark report, Super Reform, the Great Pension Squeeze, was released. So they released their report, which is looking at the impact of recent super reforms on pension assets. So they're suggesting that the dual forces of the TRIS change and the introduction of the $1.6 million transfer balance cap has forced assets to move into accumulation and mixed phases. So as at June 2018, the asset value in accumulation phase is $422 billion. That's a 90% increase from March 2017. So the hard-hitting impact of this change is now almost 25% of SMSF tax-free assets have lost that status. All right, unexpected events. This is something that we don't always think about, people don't like to talk about, but it's something that's important to consider really in regards to all aspects of your life, but we're going to look at it in the context of managing a self-managed super fund. So you need to look at what will you do if a member leaves? How would your SMSF be affected if one or more of the fund members decided to exit the fund? So what happens, for example, if you have an SMSF that is heavily weighted in real estate? You might have to sell the asset. You might have to introduce a new member to allow the exiting member to transfer out of their fund. Separating couples. This is something that we deal with a lot. So family law contains a number of options for superannuation to be split between a couple who separate or divorce. Your superannuation is treated separately to your other property. So specialist advice may be needed. Get your SMS advisor involved before you get, or get them to work with your lawyers in conjunction would be something that I recommend. Okay, reviewing your insurance. So SMSF trustees should regularly review the insurance as part of preparing their investment strategy for the fund. So this includes considering whether or not insurance cover should be held for each SMSF member, and your insurance cover may be essential if an unexpected event occurs. In some circumstances, you may already be holding insurance through your membership in a large super fund, which may exist, the policy may exist due to an employment arrangement, and often it's more cost effective to have that insurance within a large retail fund than it would be to hold it within your SMSF. However, not all insurance premiums are the same, so you should always seek advice to help you understand your insurance needs. Death. Nobody likes to talk about it, but it's something that happens to all of us. So you need to think about where you want your superannuation to go on your death. So given the introduction of the $1.6 million transfer balance cap, which means that larger sums of money may need to leave the superannuation system sooner, planning has never been more important. You need to think carefully about who receives your superannuation on your death to maximise its benefit for your beneficiaries. Now, the rules of your SMSF, as set out in your trust deed and the related documents, determine how the trustee structure is to be reconstructed on the death of a member, as well as how death benefits are to be handled by you and your fund. A corporate trustee will continue to control an SMSF and its assets after the death or incapacity of a member. This is a significant planning issue for an SMSF as well as for estate planning for its members. We still see a lot of older superannuation funds that we work with that still have individual trustees. So, you need to consider what that means if something happens to you. Okay. A lot of careful consideration needs to be given to understanding the members' wishes to ensure that your fund's trust deed and the broader governing rules are drafted appropriately to help you achieve your requirements. And there are legal tools to help direct your superannuation fund, which can include making a binding death benefit nomination to nominate who will receive your superannuation on your death, or providing for your pension to continue, or a revert, which is your reversionary pensions, to a permitted beneficiary, such as your spouse, following your death. Okay, and that's where I skipped ahead about corporate trustee. Okay, another key unexpected event that you need to, consider is diminished capacity. What are the consequences if you become unable to act as trustee due to, for example, mental incapacity? You can appoint an enduring power of attorney who will act in your place as trustee if required. This is someone who can be trusted to handle your financial affairs and can be appointed as trustee of the SMSF. So talking about diminished capacity, and in particular an enduring power of attorney, leads in perfectly to our next bunch of slides, which is where we discuss the recent Norman case. Okay, so recently the Supreme Court of Queensland handed down a decision that will have wide-ranging impacts on the future of estate planning, binding death nominations within super, and the appointment of attorneys and restrictions and powers in enduring power of attorney documents more generally. So Brett Griffiths, our Director of the Superannuation Advisory, engaged and assisted Cooper Grace Ward on behalf of the trustees of the Superannuation Fund to ask the court about certain outcomes. So in order to be able to pay a death benefit from the self-managed super fund, the court was asked to determine three following issues. The first was, given the issues that there were with an execution of a 2000 deed of variation and the impact of this on the subsequent 2014 variation, we asked the court to determine who the current trustee is and what the current rules of the SMSF were for the purposes of paying out the death benefit. The trustee was unable to locate any original documentation relating to the establishment of the pension or the nomination of the reversionary beneficiary. So the court was asked to determine on that, as well as the validity of two binding death benefit nominations that were made by the members' attorneys under an enduring power of attorney. Okay, so our first issue, sorry, can't speak today. Our first issue was a declaration as to which deed contained the current terms of the fund. So the fund was established in 1992 for the purpose of providing superannuation benefits for its sole member. Between 1995 and 2000, the terms of the fund were varied several times, and in the 2000 year, a new corporate trustee was appointed. In 2007, the terms of the fund were again varied. However, there was an issue regarding the execution of the 2007 variation deed. Now, this issue arose because it was signed on behalf of the trustee company by the member only, stating that he was signing on behalf of the company as its authorised representative, not saying that he was signing this in his capacity as the director and secretary of the company, which he was. So accordingly, the 2007 variation deed was not executed as a deed by the company in accordance with Section 127(1)(b) and 3 of the Corporations Act. Thus, it did not constitute an effective exercise of the power to amend the fund deed. There was, however, a further amendment of the fund deed in 2014 by a deed of ratification that was executed on 22nd of August 2014. One of the reasons for doing this was to fix the problem that was arising from the deficiently executed 2007 deed, which had been noticed by our one and only Rhett Griffiths of Vincent's. So while the 2014 deed purported to ratify the execution of the 2007 deed, it was submitted that it cannot, as a matter of law, have had that effect. It was argued that the 2007 deed was of no effect due to its deficient execution, but nevertheless, the 2014 deed should take effect as a valid exercise of the power to vary the deed due to a clause that existed in the 2004 deed. Now, the court accepted the submission that the variation affected by Clause 2 of the 2014 deed meant that we had a valid and effective variation. So as this occurred, according to the powers as it appeared in the 2004 deed. So as had occurred in the 2004 deed, the terms of the 2014 deed were varied to replace all of its provisions, and so the 2014 deed was valid. So the second issue that we had was that we had a lifetime compliant pension and a reversionary pension, but we couldn't locate the original documentation. So the financial statements for the fund show that, as at the member's death, he had an accumulation account and was in receipt of a lifetime complying pension, and that his spouse was nominated as the reversionary beneficiary of that lifetime complying pension. As I mentioned, the documentation relating to the establishment of the pension and the nomination of the spouse as the reversionary beneficiary could not be located. There were extensive inquiries that were made by the solicitor and also by our office when we took over the fund. Brett even conducted a thorough search of the member spouse's house to try and find documents that were held in archive boxes at the member's home. Couldn't find anything directly relating to the establishment of the fund or the establishment of the pension, but he did find correspondence between the member and a former advisor. It dated back to 2000. That correspondence included advice given to the member about commencing a complying pension upon him reaching age 65, and also that the nominated beneficiary of the pension should be his spouse. Then in May 2005, there was further correspondence, including information about the administration and the compliance procedures required to implement the complying pension. Numerous other documents were provided to the court to support the pension establishment and reversionary nomination, including material from the actuary, then Benzula, now Curium, which confirmed the establishment of the lifetime pension reversionary to the member's spouse. Due to all of these supporting documents provided, despite the original documentation relating to the establishment of the lifetime complying pension and the nomination of the reversionary beneficiary, the court determined that there was sufficient evidence both of its establishment and the nomination of the member's spouse as the member's reversionary beneficiary. That left us with the third issue before the court, the binding death benefit nominations. So prior to engaging Vincent's, the member had made 5 binding death nominations between 2010 and 2013. The final notice, dated the 5th of June 2013, was set to lapse after 3 years. However, the issue that arose was shortly after making this binding death benefit nomination, the member lost capacity. Prior to the binding death benefit lapsing in 2016, following advice from our office, the trust deed was updated to allow for making a non-lapsing binding death benefit nomination, and the members' joint attorneys signed 2 documents. So they signed a new binding death benefit nomination and a letter to the trustee of the fund confirming an extension of the 2013 BDBN. The extension of the 2013 binding death benefit nomination confirmed the terms of the original 2013 BDBN, which had nominated that 5% of the death benefit be paid to a person who was not the member's dependent or legal personal representative. Now, to avoid the potential of the 2013 BDBN and the extension being declared invalid due to the nomination of a non-dependent, the new BDN signed by the attorneys changed the nomination to split the 5% between the remaining dependents nominated in the original 2013 BDBN. So this left us with some questions, or the court with some questions. Were the binding death benefit nominations valid? So first, the court confirmed that the original BDBN made by the member in 2013 was a valid nomination, despite the fact there was 5% to a non-dependent. Although valid, the 2013 BDBN had lapsed, so it could not be relied upon. The court accepted our submission that 5% nomination to the non-dependent does not affect the validity of the nomination as a whole. So second, the court held that an attorney has the power to make a BDBN on behalf of a member. The court determined that there is no restriction within the superannuation legislation prohibiting an attorney from making a BDBN on behalf of a member, and in this case, the terms of the deed specifically allowed it. So the BDBN is a matter that relates to a member's financial matters. Therefore, it is a financial matter that can be delegated to an attorney. Third, the court had to consider whether the extension of the BDBN or the new BDBN made by the attorneys was a conflict transaction. As one of the attorneys, all their family members would benefit from the nomination. So in this respect, the court agreed that the reason for making the extension of the original BDBN was to ensure that the members' estate planning wishes were carried out, so the attorney's interest coincided with the members' interests rather than conflicting. However, in determining whether the making of the new BDBN, which reallocated the 5% invalid nomination, the court did not accept this was not a conflict of interest. And in the absence of the member's enduring power of attorney document allowing such a conflict, the new BDBN could not be valid. So, what does this tell us? What are we learning from this? We are learning that you need to take care with your enduring power of attorneys and your binding death benefit nominations. This decision provides clarity on the important issue of whether an attorney can make, renew, or extend a BDBN on behalf of a member. Existing estate plans, in particular enduring power of attorneys and binding death benefit nominations, need to be reviewed to ensure the following: that the enduring power of attorney documents allow attorneys to renew, extend, or make binding nominations on behalf of a member where appropriate, and that attorneys are not given inappropriately broad powers that potentially allow them to make a nomination that is inconsistent with the member's estate planning wishes. We've made a note there to say we see many enduring power of attorneys where all conflicts are authorised. So advice on the appointment of an attorney on whether to include and the drafting of conflict clauses will now need to be considered with extreme caution in light of the Naraman's decision. Attorneys seeking to make, renew, or extend a binding death benefit nomination on behalf of a member need to exercise that power with care, having regard to the member's wishes, the terms of the SMSF trust deed, and the terms of the enduring power of attorney. That's that slide. Okay, that is it. Thank you for bearing with me with the original, with the 5 minutes of technical issues that we had in the beginning. A little slide on the Superannuation Advisory team. So that concludes today's quarterly superannuation tax update. So Vincent Superannuation Advisory, we're here to help work with you to ensure that your self-managed super fund structure is fit for purpose to achieve your desired outcomes. We can help you with SMSF, structuring and strategy advice to help ensure that your investments are held in the most tax-effective way, and when held in super, that they comply with all of the strict relevant super legislation and regulations. Retirement and estate planning, as you will have gathered from the previous slides, this is such a critical area. You want to make sure that your super goes where you want it to in your death. So we can help you, including the facilitation of the preparation of binding death benefit nominations and trust deed updates. We will work with you and your lawyers to ensure your superannuation estate matters are set up to achieve your desired goals and go to your nominated beneficiaries. Had this been the case in the Naraman case, there would have been several $100,000 extra that could have been distributed to the beneficiaries. It makes a difference. It's a few $1,000 outlay up the front versus hundreds of thousands of dollars. It's something that people really should consider, and clearly we feel very strongly about. We also offer a range of consultation services to both SMSF trustees, accountants and lawyers, whether it be assistance with some technical compliance matters, assisting with super and divorce settlements, or acting as court-appointed expert witnesses. Thank you for today. If you have any questions in relation to any of the material, please don't hesitate to contact me with my contact details on the first slide. This video will be uploaded to our YouTube channel. And if you have any questions, as I said, get in touch. Thank you.